We primarily focus on two areas of practice. The first is corporate law, which includes entity formation and business transactions. And the second is privacy and security law. As Jackie noted, I've been practicing for 20 years, and my experience also includes the practices of intellectual property, and as noted, corporate transactions, and most recently, data privacy. Today, we've set aside about an hour to discuss the new Connecticut Data Privacy Act. In addition, since this may be a new topic for some, we'll go over some general information regarding data privacy and touch upon some other Connecticut laws that relate to data privacy. This is a robust topic, and it is definitely a lot to go through. We could probably spend a few hours together learning about data privacy and the new law in Connecticut. So please bear with me if I'm unable to address any topic that may be of interest to you. And please let Jackie or Melissa know if there are topics that should be addressed in another webinar. Since I'm an attorney, I need to make my attorney disclaimer that this is not legal advice and it's for information purposes only. If you have questions regarding this law or any data privacy law, please seek advice from an attorney regarding your particular situation. Okay, let's get started. Some of you may be asking, what exactly is data privacy? Some of you may have heard about data privacy or data protection and may have a general idea of what it is. Some of you might not have even heard of it before. While preparing for this presentation, I did some research on what data privacy means. Unsurprisingly, I found several different definitions. The one I like most is put on my slide. And it's that data privacy is concerned with an individual's ability to determine when, how, and to what extent their personal information is shared or communicated to others. However, I would be remiss to not include that data privacy could also mean the proper handling of personal information. Additionally, it could mean a discipline that includes rules, guidance, or guidelines, practices, and tools that help entities establish, maintain, and enforce certain levels of compliance with relevant laws concerning personal information. At its essence, no matter what definition of data privacy you like, data privacy is concerned with personal information. To further complicate things, you might also hear the term data protection. Data privacy and data protection can sometimes be used interchangeably. Data protection really is directed to keeping personal information safeguarded by certain measures from a breach or unauthorized access. So I've used the word personal information a bunch of times. What does personal information mean? Again, here's another place where you might hear the term personal information or other terms used to kind of collectively describe what identifying information about a particular person. So personal information could be known as personally identifying information, or PII, or shorthand PI, or personal data. So you might hear me just use all these terms throughout this presentation. Please note that I am not using them in a particular manner to mean different things. I'm just using them interchangeably because that's kind of how my world is. And so personal data, PI, PII, personal information, all mean the same thing in this context. And it's, in general, information that allows a person to be identifiable. So think name or first initial last name, address, email address, IP address. Those are examples of personal information. And I also wanted to note that for the purpose of this presentation, Given the scope of the Connecticut Data Privacy Act, we're going to be talking about personal information in the context of consumers, meaning you or I going out and shopping or visiting websites, not you or I going and applying for jobs or acting as an entity that is hiring employees. I also wanted to note that different laws define personal information differently. So you might have very specific definitions in certain laws or a very general statement about personal information in other laws. Additionally, to confuse it even more, certain jurisdictions do call it personal information, while another jurisdiction calls it personal data. So just keep in mind that the concepts are similar, but actual definitions may differ. So there are numerous laws that relate to data privacy. You may already be familiar with a few, including the GDPR, which is Europe's data privacy law, and is applicable to data controllers and processors that process personal data of European residents. There are also other non-US laws, such as data privacy laws in Canada, China, Japan, and Brazil. GDPR and other non-US laws are outside the scope of today's presentation, but they might be applicable to your organization. So you might already be familiar with them. You may also be familiar with federal laws in the United States, such as HIPAA, GLBA, and FERPA, which are laws that apply to certain sectors, such as healthcare for HIPAA, financial services for GLBA, and FERPA is in the education sector. Then we have US laws that apply to data breach notifications. Those are on the books for all 50 states and DC. They require entities to notify residents about breaches that impact the residents' personal data. Notification of a regulator, such as an attorney general, may also be required under these laws. And then you may be familiar with some US state consumer data privacy laws. For example, you may be familiar with the California Privacy Law, which is referred to as CCPA. California was the first state in the nation to enact a consumer data privacy law. That list has grown to now include Connecticut, Colorado, Utah, and Virginia. All of those states will have laws regarding consumer data privacy in effect by January 1st, 2024. You may have noticed one gap in my list, and that is the fact that the United States does not have one federal consumer privacy law. Currently, we have a patchwork of state laws that address this matter. Legislation has previously been introduced at the federal level, but has not been passed, and such a law continues to be a topic of conversation amongst privacy professionals and advocates. Even though we don't have one US federal consumer privacy law, you should keep in mind that even if your business is not located in a particular jurisdiction in the US, you may still be subject to that jurisdiction's data privacy laws in view of your activities in that jurisdiction. And that's also applicable to non-US laws. For instance, some companies based in Connecticut may be subject to GDPR because they have customers or clients based in Europe. So why do data privacy laws matter to me? Well, data privacy laws matter to you probably in a business context and a personal context. In many jurisdictions, privacy is a human right, and data privacy laws are enacted to protect this right. As a business, you should be concerned with data privacy laws to be in compliance with them, because more and more states are enacting laws that require businesses to post privacy notices, allow consumers to exercise rights, and set minimum thresholds for maintaining personal information in a secure manner. Additionally, even if you are not subject to a particular data privacy law, you might want to pay attention to it in view of consumer trust. More and more consumers are becoming savvy with respect to privacy, and they want to ensure that the businesses that they are working with or going on their websites take privacy seriously. As I note on this slide, the move to online commerce has come with more advertising, tracking, and monitoring. Many consumers and website visitors do not want businesses to advertise to them or track them or monitor them. So even if you're not subject to a data privacy law, your consumers might want you to be cognizant of those requirements and be respectful of privacy matters. Who enforces the laws? Well, this depends, which is a typical attorney answer. So it depends on the jurisdiction. In general, each law has a regulator or a supervisory authority that oversees compliance with the law. For instance, in Connecticut, it's an attorney general. Some states, like California, have created an agency that enforces compliance with the law. But I also wanted to flag to you the Federal Trade Commission. As I mentioned before, the US does not have a single federal consumer data privacy law. The states that have consumer data privacy laws on the books either enforce the laws with an attorney general or an agency. However, the Federal Trade Commission also works to hold businesses accountable under Section 5 of the FTC Act. Section 5 of the FTC Act bars unfair and deceptive acts and practices in or affecting commerce. This is applicable in the data privacy context because, for example, if you post a privacy notice on your company's website and that privacy notice is not truthful or leads a website visitor to believe you do something when you do not, the visitor can complain to the FTC, and the FTC can take action against you under the FTC Act. You may have seen recent rulings in the news about the FTC. They will take action against companies for misleading statements in their privacy notice. And this is the point where I tell you that while privacy notices are required on all data privacy laws, many people who are not subject to those laws still put up a data privacy notice. And it's incumbent upon everyone, whether you have to comply with a particular law or not, to review those notices on a fairly regular basis and update them as necessary, so you're not running into this unfair or deceptive practice rule under the FTC Act. Okay, so with all of that background out of the way, we can finally discuss what is the Connecticut Data Privacy Act. This act is Connecticut's consumer data privacy law that was signed on May 10th, 2022, and goes into effect in less than a month on July 1st, 2023. As I noted before, it is one of 5 states that by the end of the year will have a consumer data privacy law in place. More and more states are coming online with consumer data privacy laws. So if you are following along with this patchwork, you should expect to see some more. I feel like every day I'm getting another notice from the IAPP or other trade organizations that I follow about upcoming laws that have either been signed and are going into effect next year or the year after, or new legislatures that are putting bills into place. So it's really a dynamic time in the data privacy world, but it does cause a lot of confusion amongst businesses on how to address all these various laws. So in Connecticut, our law gives the rights to, gives residents certain rights over their personal data. And again, these are residents acting in individual or a household context, meaning you or me going to a website, going to a store, purchasing things. It's not for residents acting in an employment context. This is contrasted to California. In California, there was a recent amendment. You may have heard of it. It's called the CPRA, California Privacy Rights Act, which brings employees, former employees, and employment candidates, as well as others, into scope of the California privacy law. The Connecticut Data Privacy Act, or the CTDPA, establishes responsibilities and standards for certain data controllers that process personal data. Okay, some more definitions. I want to be clear here because, like I said at the top of this presentation, definitions about personal data range. While it is a general idea of what personal data or personal information is, each jurisdiction that has data privacy laws on the books has come up with their own definition. So let's look at what Connecticut says. Personal data is the term that they use, and it's information that can be linked to an identifiable individual. It does not include publicly available information. Examples include home address, social security number, passport information, login credentials, and IP addresses. You may have heard me in the previous slide say that the CTDPA imposes responsibilities on controllers. Controllers are an individual or entity that collects and processes personal data and is responsible for responding to consumer requests about the collection and processing of personal data. So an example is a business that has a website and uses cookies and analytics to collect IP addresses. More definitions. Because what is a processor? So under the CTDPA, a processor is an individual or entity that processes personal data on behalf of a controller. So a controller is controlling the data and determines what is done with the data. A processor may be given that data and told by the controller, do X, Y, and Z with this data. In that scenario, the controller is providing instructions to the processor, and the processor is processing. The processor cannot independently take that information or that data and decide what to do with it because they are interacting in the context of controller to processor. And so what does processing mean? So it's any operation or sets of operations that are performed, whether manual or automated, on personal data or sets of personal data, such as the collection, use, storage, disclosure, analysis, deletion, or modification of personal data. So to put it into context, several of my clients are in the role of controller, and they hire service providers to process certain information. And in one example, the service provider is told, okay, here is our information. We want you to take this personal data and then send out emails to these people. That is an example of controller and a processor. And there needs to be, we haven't gotten to this slide, but there needs to be a written contract between the two. The majority, if not all, of data privacy laws address sensitive data. In Connecticut, sensitive data is a subset of personal data and includes data that reveals racial or ethnic origins, religious beliefs, mental or physical health conditions or diagnoses, sexual activity or orientation, citizenship or immigration status. Excuse me. It also includes genetic or biometric data used to uniquely identify an individual. Biometric data, that an example would be a retina scan, perhaps a fingerprint. Personal data of a child under the age of 13 is sensitive data, and precise geolocation data is sensitive data. I have a note here that under the Connecticut DPA, a controller needs a consumer's consent to process sensitive data. I could probably spend a full hour just on this slide talking about sensitive data, what companies should do about sensitive data, how to get consumers' consent to process this sensitive data, etc. But unfortunately, we're limited in time, so I won't be able to discuss that fully. But you might start seeing, if you haven't already, on websites, banners or buttons, links that talk about sensitive data, like do not process my sensitive data, do not sell or share my sensitive data. A lot of these are holdovers or have been in place in view of the California privacy laws, but more and more states are coming online that have similar or the same requirements. So as a consumer, when you're interacting with websites, you might see more and more of these links or buttons regarding do not sell, do not share, do not use my personal data or my sensitive personal data. So is there anything excluded from personal data under the CTDPA? Yes. So as I mentioned before when we were going over the definition of personal data in Connecticut, personal data does not include information that is publicly available. So publicly available information includes information that is lawfully available from federal, state, or municipal government records or widely distributed. And a controller has a reasonable basis to believe that a consumer has lawfully made that information available to the public. Also excluded from the definition of personal data is de-identified data. It's a long definition that I've included here, but in general, it's data that can't be reasonably used to infer information about a particular individual or a device that's linked to that individual. But again, personal data in Connecticut is anything that can be used to link to a particularly identifiable individual, and only in the consumer space. Okay, so who must comply with the CTDPA? Each of the US states that has a consumer data privacy law has certain thresholds or requirements that need to be met in order for the law to be applicable to them. Some jurisdictions look at revenue, Others look at number of records of personal data that are maintained. Others look at whether the entity sells personal data, and some look at a combination of all of this. Connecticut's law applies to people or entities that conduct business in Connecticut or who produce products or services targeted to Connecticut residents, and that during the prior calendar year controlled or processed the personal data of at least 100,000 Connecticut residents, but that excludes data used solely for completing a payment transaction, or 25,000 or more Connecticut residents, and has derived over 25% of gross revenue from the sale of personal data. So I want to note a few things. Number one, you don't have to be a person or a business that is incorporated or has a location in Connecticut for the Connecticut DPA to apply to you. If you are producing products that get sold to Connecticut residents or services that are targeted to Connecticut residents, and you meet the other parts of this threshold test, the Connecticut DPA applies. Let's go over this number threshold. At least 100,000 Connecticut residents that you either controlled or processed the personal data of. 100,000 residents in Connecticut sounds like a lot, and I do think it is a high threshold. However, if you think about it from a website perspective, if you have a website and you are using that website to promote your business, perhaps offer products and services through that website, and you're collecting data about visitors that come to your website, you use analytics, you see IP addresses, you might have a contact me button, and that contact me button, they can put their name, address, or email address, etc. If you are getting about 8,300 hits from Connecticut a year, you've reached the threshold of 100,000 Connecticut residents. Also note, I've been attending the Connecticut AG's office has been great in trying to get out the word regarding this new law. So I would not be surprised if several of you have attended one or two of the AG's presentations. The AG's office has noted that this is a cumulative number. So if you're not purging your personal data every year and you just allow it to accumulate year over year and you're retaining that, if you have it on the books, if you have it in your possession, you're controlling it or you're processing it, it looks like you're meeting that threshold number in Connecticut. The number drops to 25,000 of Connecticut residents when you are actually selling personal data, and 25% or over 25% of your gross revenue is derived from that sale. And I know a lot of people, when I speak to them, they're like, oh, no, we never do that. There are businesses that do that. There are good reasons that businesses do that. Data brokers do exist, and that number was dropped to, from my understanding, to make sure those types of businesses are in compliance with the Data Privacy Act. Okay, I made my own one slide for this, one note, because I think sometimes this gets lost when talking about data privacy laws and who must comply with them. It's important to note that even if a business does not meet the previously described thresholds, the CTDPA could still be applicable to a business if they are a service provider that maintains or provides services involving personal data on behalf of a business that is subject to the law. So for myself, if I had a business that sends out, I engrave things, and a controller comes to me and says, we would like to have engraved um, plates for this list of 250 people. And then I would like you to mail out that all of the plates to the people at these addresses. And the controller is telling me what to do. So all I'm doing is I'm taking this information, I'm engraving it on a plate, I'm using that information to ship out to these residents. If that's all I do, I'm a small business, I get maybe like 100, 200, 300 names in any given month. I certainly don't reach 100,000. If the businesses who are hiring me to do this service for them are subject to the Connecticut Data Privacy Act, then I am also subject to the Connecticut Data Privacy Act, because now I am also using that personal data, names, addresses, I'm storing it in my Excel spreadsheets, on my server, etc. So I need to be cognizant of these laws as well and also comply. So this brings into scope many businesses that might not be B2C, and only operate in the B2B space. So are there exemptions from the CTDPA? Yes. So there are exemptions at the entity level and at the data level. And this, I think, is pretty similar to other state privacy laws. They offer exemptions based on either your entity level or your data level, the data you process. So exempt entities include state and local governments, nonprofit organizations, financial institutions that are subject to the GLBA, national security associations, entities subject to HIPAA, and higher education institutions. Excuse me. There's also, like I said, exemptions at the data level, and that includes certain types of personal data maintaining compliance with employment, GLBA, HIPAA, the Fair Credit Reporting Act, FERPA, and other laws. So now that we've gone over everything about what the CTDPA is, the thresholds, what's exempt, what is personal data, what does a business have to do to comply with this new law? So this is, I feel, the most overwhelming part, because businesses often have to comply not only with one state's law, but other states' law as well. And you might be asking yourself, well, if I've already complied with California, do I really have to do anything else? I mean, I'm in compliance with California. And the answer is, well, it depends. Certain laws have different nuances to them. A lot of data privacy laws have similarities, but some laws have specific requirements that are not pertinent to other data privacy laws. So it's important to go through what you're doing and then compare it to what the new law that's coming online, Connecticut, requires. So here's just a small list of the obligations in Connecticut. The first is businesses have to, who are subject to this law, have to post a privacy notice. And again, the privacy notice needs to be, it has to be truthful, it has to be transparent, you can't be deceptive, and it should be reviewed on a regular basis and updated as necessary. Businesses need to limit the collection of data. You should also have reasonable safeguards, and we'll get to this in the next slide, but all data privacy laws have this requirement of reasonable safeguards, and this goes to the cybersecurity. You have to put reasonable safeguards in place to maintain the privacy of the personal data that you're collecting and using. Data privacy cannot exist without data security, or sometimes you can hear the term cybersecurity, but reasonable safeguards must be in place. You must get consent with respect to collecting and using sensitive data. You must allow for consumers to exercise their rights. You have to disclose the sale or use of data for targeted advertising and allow an opt-out. You cannot discriminate against consumers who exercise their rights. You also have to have a written agreement with contractors, and those are the service providers that I was talking to you about in another slide. So in that instance, that example of me being an engraver, and a business comes to me and asks me to engrave plates, we should have a written agreement in place that talks about what my requirements as a service provider are in accepting this personal data and what I'm going to do with it. So written agreements with contractors when personal data is involved must be in place. And then also data protection assessments are required when there is a heightened risk of harm. So if you're collecting sensitive information from folks and using it, you might need to undergo a data protection assessment to ensure that the security and the protection of the information is maintained. Okay, so processor contract requirements. Again, me as the engraver, what should I be expecting to see in this written agreement? Usually, I just take an order and fulfill it. This sounds overwhelming to me. Well, other data privacy laws have similar requirements. You, as a business, may have already seen a data processing agreement or a data processing addendum. Of course, being privacy, there might be other names: data protection agreement, data protection addendum. They're commonly referred to in the privacy space as DPAs. And essentially, they are contracts that are required to include provisions that provide processing instructions, rights and obligations of both parties, and requirements that are put on the processor. So in our plate engraver scenario, the processing instructions would be: business is providing to engraver data, personal data, to put on plates and mail plates out. The rights and obligations of both parties: the business as controller, they're going to provide legal instructions. They're going to make sure they have consent to provide this information to the engraver. They're going to also make sure that if something is wrong in the data that they've provided, they will update. And the engraver is going to agree to only use the information for the specific purposes of this agreement. So they're only going to use it to engrave the plates and mail out the plates. We have to make sure that the processor has a duty of confidentiality, that it returns or destroys all the personal data. The engraver should be able to either demonstrate compliance with data protection obligations or allow the controller to come in to confirm. If I, as the engraver, am hiring a subcontractor to complete this task, I also have to allow the business to object to that, and then ensure that the subcontractor, if we do use them, is subject to the same requirements. And I also, as the engraver, have to cooperate with reasonable assessments of policies and technical and organization safeguards that will confirm to the controller that I am in compliance with what I've set forth in the agreement. Okay, I know we're coming close on time, I think, because I want to allow time for questions. But consumers' rights. There are many consumers' rights under the Connecticut DPA. This is similar to many of the other states and other laws that exist regarding data privacy. In Connecticut, consumer rights include the right to access personal data that a controller has collected. And you even, as a consumer, have the right to confirm whether a controller has that personal data on you. You have the right to correct inaccuracies. You as a consumer have the right to delete your personal data at a controller. However, note that controllers may be able to retain that data in certain instances to comply with other laws. You have a right as a consumer to obtain a copy of your personal data. You might hear of this as the data portability right. And consumers have the right to opt out of sale of their personal data, processing of personal data for purposes of targeted advertising, and profiling that may have legal or a significant impact. Consumers exercise this right through the information that is provided by the controller. So the privacy notice must clearly identify how a consumer can exercise their rights. You may see phone numbers, emails, a link on other websites as examples of how you can exercise your rights. And there should be a link on the website to opt out of targeted advertising. A controller must respond to a consumer's request. You cannot ignore it. You have to respond as a controller no later than 45 days after the receipt of the request. Note that you can deny certain requests. Under the CTDPA, consumers can appeal a controller's denial. That's not necessarily true in all jurisdictions, but it is applicable in Connecticut. Okay. As I mentioned at the top, the Connecticut Attorney General has enforcement authority of the CTDPA. There is no private right of action under the CTDPA, so that means that I, as a consumer, cannot sue a business for failing to comply with the data privacy law. I need to contact the Attorney General, register a complaint. The Attorney General can investigate and choose to pursue. A violation of the CTDPA is an unfair trade practice. You have an initial violation, which may result in an injunction or an order directing restitution or both. If there is a willful violation by a controller, you may also, the controller may also receive a civil penalty of up to $5,000 per violation. Now, again, the Connecticut law is not in force right now. It goes into in force on July 1st. So I don't have any examples of how the Attorney General has enforced this law. But right now, there is a cure period that's contemplated. If the Attorney General determines a controller could remedy a violation, right now the Attorney General must give the controller notice of the violation before filing suit. Now, of course, the Connecticut AG might determine that the controller can't remedy the violation, in which case they don't have to give a right to cure. But if they are giving a controller the right to cure, the controller has 60 days to fix what the Attorney General has flagged to them as a violation. This cure period is only available until December 31st of 2024. Okay. There are other Connecticut laws that relate to data privacy. We have the data breach notification law, which we talked about. All 50 states have this. So if you have a data breach or a data incident that results in the unauthorized access of personal information, you need to contact those individuals affected, and you may have to also contact the Connecticut AG's office. We also have a data security law. Many states, now this is separate from what is required under the Connecticut Data Privacy Act. The Connecticut Data Privacy Act requires businesses that are in scope of that act to have certain safeguards with respect to keeping personal data secure. This is a different act. This is a safe harbor law, and it's an incentive for entities to adopt written cybersecurity programs that conform with recognized security standards or other applicable laws. And that includes the NIST cybersecurity framework, CIS controls, also certain ISO frameworks, also certain laws such as HIPAA and GLBA. Then Connecticut also has the Social Security Number Protection Law, and that's been on the books for quite a while. And that relates to any person or entity that's in possession of Social Security numbers. They must safeguard them and must create a privacy protection policy that shall be published or publicly displayed. Okay, so again, I'm pushing the limit, but next steps. If you're interested in determining, if you're interested in this law, you think it might be applied, you should review the thresholds, determine if your business is subject to the law. Also consider other laws that might be applicable to your business within the data privacy realm. Review the Connecticut Attorney General's website for information and updates about the law. Right now they have a FAQ and they have other information concerning the law. There's plenty of data privacy and security professionals within the state to and you can consult with them to determine if your business is in compliance. And I think the most important thing, if you get anything out of this, is to limit the amount of data you collect. If you don't need the data, don't collect it. All right, so thank you again for attending. I'm going to see with Jackie and Melissa whether or not there were any questions.
Hi, yes, thank you, Elizabeth. Yes. So one of the first questions was, and you had mentioned this earlier on in your presentation, but if you can return back to it, is if you see the federal government passing any type of federal legislation in regards to data privacy.
Yes, so there was a bill last year that was working its way through Congress, and that was ultimately not passed. I think it would be very beneficial for businesses if the federal government did enact one law so we don't have this patchwork throughout the country. I am hopeful that we will get there.
Great. And in connection to that question, do you know if the U.S. is looking to provide any type of harmonization on the federal level law with any, say, GDPR or any other country's laws to try and come up with more of an international law?
That would be helpful, and it would make my job easier if there was just one law in each country that we had to comply with and we were harmonized. My recollection of the previous bill that was moving its way through Congress, I don't think that the goal was to harmonize with Europe. So I don't see that as something that is a goal, but I'm sure that many people would like to see that.
Yes, yeah, thank you.
Mhm.
And so one of the other questions is, are IP addresses included in personal identifiable information? And you're
Yes.
saying yes, they are. And another question related to that is somebody had mentioned in the Q&A that their service provider actually switches the IP address automatically every 3 months or once a year. So how does that impact a company's compliance if the person's IP address is being changed on a regular basis?
Yes, I know. We struggle with that. That is a question that's a very nuanced question. I see it in the Q&A. Um, we struggle with that as data privacy professionals, and I can tell you that my clients, my big multinational clients, struggle with that as well. Um, I think, just based on feedback that I've gotten um, from Jackie and Melissa, and just like kind of screaming through this presentation, trying to get enough information to you guys. I think it's ripe to have a conversation concerning technical aspects of data privacy and security laws, and maybe we can delve into this more in that webinar.
Okay, perfect. Thank you. And then there was another question about cookies, if cookies are considered de-identified data.
Hmm, I've not run into that question. Um, I don't know the answer to that.
All right, well, that's fine. If we're able to find the answer, we'll include it in the follow-up email that we provide.
Mhm.
And then I thought in our prior discussions, we had talked about if you can talk a little bit more about the B2B, I think, aspect of this law. I thought B2B, and I thought the other piece that you brought up earlier it was interesting about number of visitors to a company's website per month. So, it's not necessarily that a company has to just be sending proactively out information. It's, when you're collecting the data, obviously on the website, but it also includes, so if you have, as you mentioned, if a company hits 8,300 visitors per month on their website, then this law would apply to them.
Yeah, so those are unique visitors. Those are Connecticut residents. If your website is getting a lot of traffic from Connecticut residents and the unique identifiers reach that threshold, um, I and IP addresses are considered personal data. It sounds like you fall within the scope of this act. Um, yes, and B2B, right? If you are, and I work with many B2B companies um, who have to comply with other state and also other national laws. Um, so it's in Connecticut, that one slide that I had about the service providers and my engraver example, where I'm just sitting there, I get business from all these different other businesses, and I'm engraving names and I'm sending them out. Um, you know, you if you are processing personal data on behalf of another company that has to comply, you need to comply as well. So it's that service provider catch-all that
And how does that impact if a company is not, they're B2B, they're not collecting, the company that's sending them information isn't
yes,
providing them
yes,
any personal
right,
identifiable information.
right.
What about the information of the business contact? So if a company just has business contact information from another business, that does not
No,
fall under
yeah,
this act, correct?
not under this act. It falls under California. So yeah. Yeah, so yes.
Okay. And then I think the last question, and then we'll wrap up because we're right at the top of the hour now, is there anywhere that open source where you can find where a company can find a good privacy notice that they could display on their website?
Good privacy notices. I don't want to give advice about where to go, but there are great examples of privacy notices on websites that you probably frequent on a regular basis.
Perfect. Thank you.
Mhm.
And with that, I'd like to thank you again, Elizabeth, and we're going to end our program for today. And to all the participants, thank you for joining us, joining the U.S. Commercial Service, and again, for the Connecticut District Expert Council. And this recording, as well as a slide deck, will be sent to you in follow-up. So everybody have a great day, and look forward. Please contact us or reach out to Elizabeth. Her contact information is on this last slide. If you have any additional questions, or if you're looking for her expertise to assist you with your business.
Thank you.